Counsel, make your appearances.
Good morning, Your Honor. This is Edward Goolsby, along with my co-counsel, Kyle Pelker from AZA. We are here on behalf of the plaintiffs. That's Timothy Lewis Seib, both individually and also as the trustee of the Timothy Lewis Seib Legacy Trust.
Good morning, Your Honor. Daniel Olds and Scott Shanes here from Clark Hill on behalf of the defendants.
Okay, we're here on a summary judgment. Before that, we need to do a motion for continuance of the summary judgment hearing. Did you want to hear that first, Mr. Olds?
Your Honor, we're pulling that down. We don't need to hear that.
Okay, you want to go forward with the actual motion?
Yes, Your Honor. Thank you.
All right, let's go ahead and proceed.
Thank you, Your Honor. Edward Goolsby on behalf of plaintiffs and the movements. Your Honor, this is a narrow and discrete issue of law we have before Your Honor today, involving a forced buyout provision in a company agreement for Seib Holdings. Just to give Your Honor a little bit of background, I represent Mr. Timothy Lewis Seib. He is here on the Zoom today. Mr. Seib is both here in his individual capacity and as trustee of his trust. The business that they are in is largely the memory care facilities, like for Alzheimer's patients. Mr. Seib's father, Richard Seib, started the business back in the mid-90s. As the business grew, they formed new entities. I'm sorry, Your Honor. Did you have a question?
No, there's somebody here. I'm telling them to come in. Sorry. I'm here at the courthouse. Can you go let her know she can come in? I don't think she knows. Sorry, go ahead.
Yes. Business was originally formed in the 90s. As the business grew, they formed additional entities. One of the entities that was created is Seib Holdings. That's one of the parties before Your Honor today. After the parents, Richard Seib and his wife, Ruth Ann Seib, decided to pass the business along to their 4 sons, Mr. Timothy Seib being the oldest. They divided the interest 25% for each of the 4 sons, and the sons held them in their trusts, not individually, but as their trusts. There's been some disputes among the brothers. The 3 other brothers want to buy out Timothy Seib from the business. They have invoked a forced buyout provision to force him out. Currently, they're paying him no distributions, even though he currently owns it through his trust. His 25% interest is owned by his trust. They will not give him access to the documents since they claim that they have bought him out. Your Honor, they have not paid him a penny for anything in this multi-million-dollar interest. So this is a very important, discrete legal issue that we come to, Your Honor, now, and this is something that could not wait until trial. And with Your Honor's permission, might I share the screen so I can show you the provisions that are at issue that you'll need to review and interpret?
I will say I've read everything, but you're welcome to do that.
Okay, thank you, Your Honor. Then I'll move along diligently. Your Honor, I just want to pop up the section 9.6 from the company agreement. This is in the Seib Holdings company agreement, that upon the termination of a member's employment with the company, this is when this provision is in effect. What you have to look at is you have to have a member, capital M, and you have to have the company, capital C. If you don't have one of those, it doesn't apply. And if, in this situation, we have neither. In this situation, for purposes of this motion, the facts aren't disputed. You have a set amount of facts from actually defendants' interrogatory responses. They have said that that provision applies because Tim Seib individually, not the Tim Seib Trust, not the Timothy Lewis Seib Legacy Trust, Tim Seib individually was terminated from a subsidiary, not Seib Holdings. The subsidiary is ALF Back Office Services. This argument does not work as a matter of law for 2 reasons. First, you have the wrong member. The Timothy Lewis Seib Legacy Trust is the owner of the interest, not Tim Seib individually. So there's never been a member that was terminated from any employment. And secondly, you have the wrong company. The company only means Seib Holdings. It does not include any subsidiaries. The definition is a very straightforward, only Seib Holdings. To the first point, members are defined as
This
persons.
first hearing is going to what I'm going to have you do your memo on.
I'm sorry, did your Honor have a question?
No, go ahead.
Oh, apologize. Your Honor, so members are defined as persons, either the persons that are originally on Schedule 1, that was originally Richard and Ruth Ann Seib individually, or any of their successors, or any persons that later get a membership interest. What is a person? The company agreement also tells us that. And under these definitions, Tim Seib individually is a separate and distinct person from the Timothy Lewis Seib Legacy Trust. How do we know that? Person is defined as the meaning is given under the Act. The Act means the Texas Business Organizations Code, and the Texas Business Organizations Code says a person is an individual, or, and they give us a lot of examples such as corporations and partnerships, and they even list as distinct from an individual, a trust. And that's very important because this definition is treating an individual as a separate and distinct person from a trust. Secondly, the definition of company is company means Seib Holdings LLC, a Texas limited liability company, period, full stop. Your Honor, I believe you'll hear from opposing counsel that they're taking the position that this very simple, straightforward definition is somehow ambiguous. And Your Honor, this is a very straightforward definition. It's Seib Holdings and Seib Holdings only. The company agreement we have is unambiguous and it's fully integrated. We have a merger clause in section 11.11 that says any prior oral or written agreements are superseded. They're not in effect. That's not what's governing this company. To the first point about we have the wrong member. The defendants didn't terminate a member. As we mentioned before, the Timothy Lewis Seib Trust owned the 25% interest. Timothy Lewis Seib Trust has not been terminated from any employment with Seib Holdings, and defendants don't dispute they haven't paid anything to purchase this membership interest. We have various documents in the record confirming that the trusts.
So let me ask you what my kind of when I read this, what my big question was, is they haven't been making this, and I guess maybe this is just to the defendant, but either of you can answer, I guess, is let's say hypothetically they have terminated your client, wouldn't he still get distributions until the transaction is completed where his interest is bought? I mean, why is he not getting distributions right now?
Your Honor, from the plaintiffs, the answer is yes. And I can actually jump to a different provision to show you. But the answer is yes, it's retained by the person until the sale is consummated. And there's a provision that speaks to that.
So why, Mr. Shanes, why isn't, or Mr. Olds, why isn't he being paid right now, these distributions?
Your Honor, he's not being paid right now because we got, this whole process began with an appraisal process that took the better part of 5 months, to which there were no objections by Mr. Seib or Mr. Goolsby throughout the course of that. We got clear through, in fact, the appraisal firm that was actually selected to do the appraisal of Mr. Seib's interest was the appraisal firm that was suggested by Tim Seib. We got clear through the process. There was the approval by the company of the amount of the buyout. We got to the eve of the closing, and Mr. Seib did not appear to basically accept the check for the valuation of his interest. We reset for a second closing. He didn't show up a second time. Now, I will say the distributions are being kept by the company, separated out, but it's our position that he simply has not folded his arms and said, I'm not going to accept the check to complete the entire process. We are ready, willing, and able to complete that closing and have been for months now.
Okay, Mr. Goolsby, why hasn't your client accepted the check?
Your Honor, I would like to, this is beyond the record for the summary judgment, but we have issued various objections. We asked for additional information. We tried to be involved in the valuation, and the evaluators actually wouldn't respond to our questions. We raised these objections. We even filed a lawsuit, and they offered another closing. We showed you can't do a forced buyout. Your Honor, they're trying to use I believe it's a $2 million discount in light of this forced buyout. They are trying to to shave off significant amounts of the value and force that down his throat. And we've been objecting to it, trying to work with them. And what they're now doing is, we're not going to give you any of the rights and any of the benefits, and you must accept this under duress. And so that is what has brought this lawsuit.
I guess, why is your client even participating in this process if he's taking the position then that he hasn't been terminated?
Your Honor, they were paying the distributions up until August. We worked with them during the valuation. And Your Honor, it's no secret that the brothers don't get along. And we thought that there was hope that there could be an amicable transaction in which his interest was bought out. That was the reason we tried to cooperate on some level. But they paid us the distributions during that cooperation period when we said, hey, the valuator has not been answering our questions. We raised objections at a company meeting, and they were summarily dismissed or ignored.
When was the date of the first closing?
It was in August, Your Honor. I believe August the 2nd,
Okay.
But I could check my records.
All right, that gives me a clear understanding of what's going on. All right, go ahead.
Okay. And Your Honor, so back to the slide here, as you can see, the trusts have owned in 25%. This is not just Mr. Seib's trust. It also, his three brothers have owned it through their trusts as well. Going to the next slide. One of the things that happened in January of 2021 through various disagreements is the other brothers decided to remove Tim Seib individually as a manager of Seib Holdings. When they did this, they confirmed for him, well, your interest, your trust ownership is intact and unaffected. It, not you, it owns 25% of Seib Holdings. They realized correctly that the removal from the manager position didn't affect it because you have the individual on one hand and you have the trust on the other hand. And furthermore, Your Honor, when we look at their petition, both their amended and their original petition, they concede, hey, before this dispute, the various trusts, not the individuals, the trusts own the 25% interest. We have a few excerpts from various paragraphs, like paragraph 21 says they owned it in 4 equal 25% shares by 4 trusts. The members of record of Seib Holdings, including the Timothy Lewis Seib Legacy Trust, were invited to appear at the meeting. And Seib Holdings alleged that it tried to determine the fair market value of Tim's trust's ownership interest in the company. And again, we're saying that that's phrased correctly. That's consistent with our understanding. And that's why the result under the unambiguous terms of the company agreement show that summary judgment is appropriate on this issue. And furthermore, when we're talking about, yes, this is the letter for the first proposed buyout. And my recollection, Your Honor, is we were getting those distributions through July. They told them, hey, we want you to come out for this buyout, and we're trying to buy the Timothy Lewis Seib Legacy Trust membership interest in the company. And furthermore, Your Honor, even in this very letter, Seib Holdings is defined as the company, no affiliates or subsidiaries or anything like that, which brings me to the second point, the second argument of this summary judgment hearing. Defendants considered the wrong company. Seib Holdings is a separate and distinct company from ALF. They have different certificates of formation with the Secretary of State. The definition only includes Seib Holdings. It only means Seib Holdings. If they wanted to have a subsidiary or other affiliates, that would be in the definition, but it didn't. ALF actually didn't exist when the company agreement was written. You'll hear from the defendants that the employment can only make sense in the context of ALF. Well, that actually isn't even, you shouldn't consider parole evidence, but it's not even technically meeting the standard of parole evidence. It's not a prior or contemporaneous agreement or understanding. It's something that happened later. And by defendant's admission, the 2 original members, Richard and Ruth Ann Seib, they actually never were employed by ALF. So ALF cannot be the determining factor for what is employment with the company Seib Holdings. And just to show you the dates, the Seib Holdings LLC's company agreement, it was written on December 19th, 2012. And then if you see ALF back office services, formed about 3 months later. We've seen this definition before. Company only means Seib Holdings, period, full stop. Defendants have taken the position that there's some kind of latent ambiguity because the members must be able to be fired, they must be able to die, be disabled, or get divorced, because there's various forced buyout provisions for a divorce, for death, for disability. Your Honor, if you look and harmonize the provisions of the agreement, that is not correct. You come to the conclusion that some of these provisions might apply to some members, but they were intended that they might never, under any circumstances, apply to others. Because you can have members and owners of this company that are corporations, that are partnerships, they're limited liability companies. For example, a corporation can't get divorced. Under the definition of disability, a partnership couldn't be disabled.
Can a corporation be fired?
I don't believe so, Your Honor. And that's just the point, is that if we're talking about employment as like an employee or as a manager, that, but in any event, let me put it to you this way, Your Honor. There's a divorce provision. And God forbid this would happen, but if there was an individual member whose spouse passes away, well, now the divorce provision could never apply, but the person can still serve as an owner and member of the group. Just because somebody has passed away and now the divorce provision wouldn't apply to them doesn't mean they can't be a member. It's a situation, logically, it's a situation where if there was a divorce, they didn't want the membership interest, the ownership interest, to be locked up in a divorce proceeding. They wanted the opportunity to be able to buy that back and pay the money. And that would be what would be in the divorce suit. In the situation of, if you have an individual who got fired, they wanted the opportunity to buy it back. But it might not be applicable if there is no employment in play. And that's why we had focused on an example with Richard and Ruth Ann. Defendants actually put in evidence that the two original members actually didn't have any employment with the company. I disagree with it slightly, but if you take their position, then you aren't guaranteed employment with the company. Now, I think that they do overlook something, and that is there is a manager position with Seib Holdings that is given some form of compensation. And even in the compensation of managers, they contemplate other forms of employment that may or may not come to pass. But this is an agreement that isn't guaranteeing employment. It may not be applicable to some members, but it may be applicable to others. And Your Honor, that's my presentation that I had for Your Honor. If Your Honor has questions, I'm happy to tackle them. Otherwise, that's my argument.
Response?
Thank you, Your Honor. Well, so that was a lot of background information, but I think legally what this motion really comes down to is how does one interpret the word member and the word company in section 9.6 of the company agreement? Now, the plaintiffs want the court to interpret this provision very narrowly. They've taken a very narrow focus on these few words. What we would ask the court to do is place this provision, place these words in this provision in the proper context within the four corners of the contract and within the context of the surrounding circumstances that gave rise to the contract and what's happened since. Now, the defendants are not arguing that a trust cannot be a member under the company agreement. I'm not sure if Mr. Goolsby is saying that that's our position. That's not our position. Clearly, a trust can be a member under the company agreement. What we're saying is when you interpret the words of section 9.6 specifically, what does member mean? And more specifically, what does it mean to terminate the employment of a member under 9.6? Now, as Your Honor alluded to, it's difficult to terminate the employment of a trust. I would argue that it's impossible because the Texas Supreme Court has held repeatedly that a trust is not a separate entity under Texas law. it is a descriptor for the fiduciary relationship between the trustee and the trust property. So it defies any sort of plain reading or ordinary meaning to say, well, they've terminated the employment of Tim Seib individually. They didn't terminate the employment of his trust. Our first argument is that just doesn't make sense under that provision. So that's number one.
Let me ask this. One of the issues that I found a little confusing is that why didn't Alf terminate him instead of am I remembering correctly? He worked for Alf, but the parent company terminated him. Is that?
Yeah, so he was terminated as manager, but he was also an employee of.
I can't hear you, Mr. Olds.
Sorry, Your Honor, can you hear me?
No, your sound is cut out.
Your Honor, can you hear me?
Mr. Shanes, are you there? Can you take over the argument? Apparently his sound isn't working.
Yes, Your Honor. I think the issue is that, yes, the parent company, because it is the parent company of Seib Holdings, effectuated the termination, but our opinion would be that's a distinction without meaning.
Why?
Because it's a subsidiary company of Seib Holdings, ALF.
Okay. All right. Mr. Olds, are you there?
Yes, Your Honor, can you hear me?
There's something wrong with your sound.
I may try to log back in and come back in.
There you are.
Oh, you can hear me?
Now we can hear you.
Okay, I'm sorry. I don't know what happened.
Okay.
So to focus on what a member means under 9.6, first of all, it defies that sort of common sense understanding of terminating an individual natural person versus a trust. But again, under Texas law, we need to read this provision against the backdrop of Texas law. And again, the Texas Supreme Court has held repeatedly for several years, a trust is not a separate entity. So to say that they didn't fire the trust, they fired the only trustee, the sole trustee of this trust, and therefore the termination wasn't effective under section 9.6, defies common sense. So we have the argument that
what is the best case that you have, Mr. Goolsby, that kind of supports your position in this case?
Oh, Your Honor, in terms of as to member or as to company?
Either.
Okay, Your Honor, I would point to the Texas Business Organizations Code for my authority on it being separate persons. One of the things that
the provision you showed me earlier.
Yes, sir. It's the law that the company agreement is actually incorporating into the document. And the other thing, Your Honor, is Mr. Olds has brought up the concept of an entity. This is from a case, Huey versus DeShazo. This was a privilege dispute where a trustee was trying to assert an attorney-client privilege over documents so it didn't have to go to a trust beneficiary. It was determined in that situation that the privilege did apply, but this isn't a privilege fight. The other case they cited, Your Honor, this Ray Maloney Trust versus Ewell, another Texas Supreme Court case, actually didn't reach the question of whether or not it's a different entity. Again, we're not looking at entities, we're looking at persons, capital P. They actually said they were looking at whether you had capacity to sue or be sued. Again, that's not a relevant issue. They looked at statutory persons. They looked at actually the Texas Government Code, which had a similar definition. And actually, they said, hey, that's a different question. Capacity to sue or be sued is different than what a statutory person is. And in that way, the Ewell case that they cited actually favors us. We're not here to talk about capacity to sue or be sued. We're not talking about privilege assertions. We're talking about what a statutory person is. And there's no dispute when you look at that statute, either it's the Texas Government Code or the Texas Business Organizations Code, an individual is a different and distinct statutory person from a trust.
Okay. What's your best case, Mr. Olds?
Can I briefly respond to what Mr. Goolsby just said?
You may.
So I think Mr. Goolsby may be confused about what we're arguing. Again, we're not saying that a trust can't be a member under the company agreement. In their reply, they cite the statutory definition of person and how it can include individuals, and trust. I completely agree. But again, it's how is member used in section 9.6. And the reason I cited those Texas Supreme Court cases, the Huey v. DeShazo case, the Jewell case, is because the Texas Supreme Court said in the Huey case, one of the litigants said, well, I should be able to get these communications because the attorney-client relationship is between this lawyer and the trust, not the lawyer and the trustee. And the Supreme Court said, no, it's between the lawyer and the trustee because they can't have their attorney-client relationship with the trust because it's not its own entity. It acts through the sole trustee. Again, in this case, the termination of employment is of the sole trustee. It's not of the trust. That's why I cited those cases, and that's what those cases stand for. But I think our best argument, Your Honor, is really when these words are viewed in context, when the word trust is viewed in context, when we look at the word member in the proper context, when we look at the word company in the proper context, within the four corners of the contract, it doesn't make sense to adopt the interpretations that Mr. Goolsbee has put forth. When we look against the backdrop of Texas law, what these words mean, it doesn't make any sense. When we look at the extrinsic evidence, how the contract was formed, and Mr. Goolsbee brought up that Alpha wasn't created at the time that Seib Holdings came into effect. He's absolutely right. Seib Holdings was created in December 2012. Alpha did not come into existence until 2013. And he says, well, they didn't say Seib Holdings and Alpha and all these other companies. It wasn't in existence then. The question is, when they said Seib Holdings in 2012, did they intend to, in the future, include its future wholly owned subsidiaries that would be formed? I would argue yes, because it doesn't make any sense, again, under common sense, under Texas law, under how the contract is formed, to say that termination from ALF isn't effective under section 9.6. We cite different provisions that would allow for competition with Seib Holdings. It just doesn't make sense. I know Your Honor's read that. I don't want to belabor the point, but I think that's our best argument, is that when these two terms are viewed in proper context, plaintiff's argument simply just doesn't make sense, Your Honor.
Okay, response?
Your Honor, in terms of the point that Seib Holdings is trying to raise about the intent of the members, the original members, trying to include subsequently created affiliates, they have not provided any evidence from the original members. That's Richard and Ruth and Seib. There is no evidence in the record. And so this would be a situation in which they have the burden to bring up a fact dispute. But Your Honor, even if they could find it, we still have a fully integrated agreement. We looked at that merger clause, section 11.11. So Your Honor, if they intended to have it, they would have put it in there. They could have put future affiliates. That's something they could have done. They chose not to do it. It's the company. It's the one LLC. That's Seib Holdings.
Okay. Let me kind of go through what my thoughts are on this. I think this is an interesting argument that the plaintiff's making. I'm not sure I fully buy it, but I do want to kind of look into it some more. To me, the real fundamental issue is, it seems like we kind of all agree that this partnership needs to end. There seems to be a difference as to, I don't know if it's a partnership, but the affiliation between the brothers needs to end. There's just a difference as to price. I have a couple of thoughts about this. One is that, I'd like to either get a have you been to mediation already?
Not, Your Honor.
No, Your Honor.
I mean, that would make sense to me to go to mediation at this point. Another option to consider is, should we get some kind of receiver in place, or not receiver, but auditor in place, a court-appointed auditor in place to try to audit, because there may be a difference of opinion there obviously is a difference of opinion as to the value of this ownership interest. Maybe having someone who's independent come in might be helpful.
Your Honor, I would point out that there's and that's what was followed through this process. There's a very detailed process as far as the selection of an independent group to value this company. And so what happened after the termination and the trigger of the buyout is that the three brothers triggering named and identified a CPA group that they proposed to do the calculation of the 25% interest of Mr. Tim Seib, and then Mr. Goolsby and Mr. Seib did not agree, and then with that selection, and so again, per the agreement, they selected their own representative, and then those two representatives that had been selected by both sides went and selected BVA Group out of Houston, which is the group that Mr. Goolsby's expert recommended. We seated that, and that was the selected. So we have gone through this process to select an independent neutral to conduct this valuation. It was simply once the number came in is when this dispute arose. And so as we view it, this process has occurred. We understand that Mr. Tim Seib and through Mr. Goolsby have certain objections to this valuation, but I think the objection is they didn't like the final number that was generated by the own independent group that they first nominated.
Your Honor, may I respond?
Sure.
We haven't been able to see the agreement between Seib Holdings and BVA Group. We've asked both. They both have refused to give it to us. We haven't been able to get the full file from BVA. Unfortunately, I don't have a personal relationship with BVA, so I've been asking for that. That's something we've wanted to see, but they will not show us. That would be very helpful. But when we asked for this stuff, we wanted to see the draft reports. Said we got the draft report and the final report at the same time, even though the valuator said that she would provide us the draft report in advance. This is a situation where the forced buyout, it doesn't apply. They're trying to cram it down his throat, and now they won't give him any distributions. And under duress, they're just trying to make him just take the deal. And that's why we're here, Your Honor, and that's why we're pushing so hard.
All right, I'll take it under advisement. I do agree that it's kind of a counterintuitive way to interpret the contract, but we'll interpret the contract as it's written. So I'll take that under advisement. We'll try to get you a decision within the month. Would it be helpful, do you think, Mr. Shanes, to go to mediation at this point or not, or what do you think?
Your Honor, I don't think our clients are opposed to a mediation by any stretch to see if we could to get to some finality relatively soon. I mean, there's not been a single deposition taken in the case. There's been a lot of document exchange up to this point, but we're certainly not opposed to that.
Mr. Goolsby?
Your Honor, I would have to talk to my client. I think we're open to a fair resolution. I think the issue, and I'll be candid with Your Honor, is we're trying to get the information about what's going on with the business. When they're shutting us out for what happened past this, buyout date, they won't show us the information. They won't pay them the distributions. We feel like we're not getting a fair shake, but have we totally shut the door? I don't think so, but I need to talk to my client.